Hello viewers, I am Mahesh Kumar Sharma, Assistant Professor, Faculty of Law and Governance, Jyoti Vidyapeeth, Women's University, Jaipur. Today we will be discuss very important topic of International Court of Justice. The International Court of Justice is the principal judicial organ of the United Nations. It was established in June 1945 by the Charter of the United Nations and being work in April 1946. The seat of the court is at the Peace Palace in The Hague of the sixth principal organ of the United Nations. It is the only one not located in New York. The court's role is to settle in accordance with international law, legal dispute submitted to it by states and to give advisory opinion on legal questions referred to it by authorized United Nations organ and specialized agencies. The ICJ is composed of 15 judges elected to 9-year terms by the United Nations General Assembly and the United Nations Security Council from a list to people nominated by the national group in the Permanent Court of Arbitration. Elections are staggered with 5 judges elected every 3 years to ensure continuity within the court. Should a judge die in office, the practice has generally been to elect a judge in a special election to complete the term. No two judges may be nationals as a same country according to Article 9. The membership of the court is supposed to represent the main forms of civilization and of the principal legal system of the world, essential that has meant common law, civil law, and socialist law. Judges may deliver joint judgment or give their own separate opinion. Decision and advisory opinion are by majority and it the event of an equal division. The president's vote become decisive with accord in the legality of the use by a state of nuclear weapon in armed conflict. Judge may be also deliver separate dissenting opinions. Its opinions and ruling serve as source of international law. Ad hoc judges. Article 31 of the Statute set out a procedure whereby a ad hoc judges set on contentious case before the court. The system allow any party to a contentious case to select one additional person to sit as a judge on that case only. It is thus possible that a many as 17 judges may sit on one case. Jurisdiction. As start in Article 93 of the UN Charter, all 193 UN members are automatically parties of the court statute. Non-UN members may also become parties to the court statute under the Article 93 subclause 2. The issues of jurisdiction is considered in the three types of ICJ cases: contentious issues. In contentious cases, the ICJ produce a binding ruling between states that agree to submit to the ruling for the of the court. Only states may be parties in contentious cases. Incidental jurisdiction. Until rendering a final judgment, the court has competence to order an interim measure for the protection of the right of a party to dispute. One or both parties to a dispute may apply the ICJ for issuing interim measures. Incidental jurisdiction of the court derive from the Article 41 of the Statute of it ICJ. Advisory opinion. An advisory opinion is a function of the court open only to specified United Nations bodies and agencies. The UN Charter grants the General Assembly or the Security Council a power to request the court to issue an advisory opinion on any legal question. Other organ of the United Nations than General Assembly and the Security Council may not request an advisory opinion of the ICJ unless the General Assembly authorized them. Relationship with UN Security Council. Article 94 establishes the duty of the United Nations members to comply with decisions of the court involving them. If parties do not comply, the issue may be taken before the Security Council for enforcement action. Law applied. When deciding case the court of applied international law as summarized in Article 38 of the ICJ Statute, which provides that in arriving at its deci- dis- decision, the court shall apply international convention, international custom, and general principle of law recognized by civilized nations. Thank you.